On January 29, 2022, Boston police officer John O'Keefe was found dead in the snow outside of 34 Fairview Road in Canton, Massachusetts. His girlfriend, Karen Reed, is accused of second-degree murder, with prosecutors alleging she struck him with her SUV after a night of drinking and left him to die. Evidence includes over 50 missed calls and several profanity-laden voicemails and text messages she sent to John O'Keefe the night he died, expressing anger and accusations of infidelity. First responders testified that Karen Reed was visibly distressed at the scene, repeatedly saying, "I hit him," as she attempted CPR. Forensic evidence includes John O'Keefe's DNA on Reed's broken taillight and hair matching his found on her SUV. The defense argues that Karen Reed is being framed, suggesting John O'Keefe was beaten inside the house during a party and his body was staged outside to implicate her. They highlight alleged investigative misconduct, including the use of inappropriate evidence collection methods and potential conflicts of interest due to close ties between investigators and the Albert family. Tonight, we are live from the courthouse in Dedham, Massachusetts, as our in-depth coverage of the retrial of the century continues. I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments. Our coverage of the retrial of the century continues, and this is a murder case, okay? We're talking about someone getting struck by a car, by an SUV, that's the allegation, but this is a murder case. It doesn't get more serious. Everything is at stake here. Everything's at stake for Karen Reed, you know, what the rest of her life is going to look like, and on the other side for John O'Keefe's family. They want the truth to come out. They want justice for John O'Keefe, who is no longer here. Now, this is a case where prosecutors say they've got direct evidence, okay? What is direct evidence? Direct evidence, the alleged confessions of Karen Reed. I hit him, I hit him, I hit him, I hit him. That's direct evidence. If the jury believes it, that's direct evidence of the crime, an alleged confession. Now, there's no video of the alleged crime. That would be direct evidence as well. There's no eyewitness to the crime. That also would be direct evidence. But you've got an alleged confession. So this isn't going to be a case where you're going to see the defense come up and say, ladies and gentlemen, this is merely a circumstantial case, because that's not what prosecutors are alleging. They say we have direct evidence here, directly from the mouth of the defendant. Now, there is circumstantial evidence in this case as well, and there's a lot of it, depending upon if you trust it, if you believe it. And for prosecutors, a big part of their circumstantial case is the broken taillight and the broken taillight pieces that are found at the scene. She's got you know, you take the circumstances surrounding what happened to John O'Keefe. Karen Reed dropped him off. He was in her car, he got out of her car. Her taillight is broken. The broken pieces of that taillight, according to investigators, are found right where she dropped him off, right where John O'Keefe's body was found. That's circumstantial evidence. So in this case, depending upon what the jury accepts or believes, you've got direct and circumstantial evidence against Karen Reed. Let's talk about some of that evidence. Joining us outside the courthouse in Dedham, Massachusetts, crime and justice correspondent Matt Johnson. And Matt, talking about evidence, there was some key evidence, crucial evidence shown to the jury today.
Key evidence, Vinny, and powerful moments in the courthouse here behind me in Dedham, Massachusetts for this retrial. Now, we've seen this evidence before, but it's always so powerful when you see it up close and personal. And the jury got that view. So there was Trooper Keefe that was on the stand today, and he was showing this jury key pieces of evidence, including that, some of the taillight that was found at 34 Fairview during the search for evidence. They also were shown broken taillight pieces and John O'Keefe's sneaker that was shown to the jury, said to be found near the curb near the flagpole. But the defense, when it came to their turn to cross-examine this trooper, they were focusing more on somebody else that was not even in the room. Listen to this.
You've worked on this case with Michael Proctor, correct?
Yes.
You retrieved videos from both the Waterfall Bar and Grill and C.F. McCarthy's, did you not?
That's correct.
But lead detective or lead investigator Michael Proctor was the one to analyze the video and write a report on it, correct?
I would have to see that report, sir.
Vinnie, you and I talked about this, I think it was earlier this week. The defense is really beating the drum, and they are tying Trooper Proctor, who is yet to be called in this retrial. They are tying him to every key piece of evidence, and he was tied today to the shoe and also the taillight.
And Matt, how about for the jury seeing those taillight pieces? You know, what do we know about how they are taking all of this in? I mean, what I gather from the reports and everything you're saying is that this jury is locked in and they're paying attention, because for prosecutors, this is an enormous day.
It's a huge day. And now we didn't have a ticket, one of the golden tickets, in court this week. So I wasn't in court, but Paul Zenzel, who's the photographer, works for Court TV. He was watching the jury today. He was in the room each and every day, and he was saying that they weren't taking that many notes today. So I found that interesting.
Very interesting. I mean, it's self-explanatory, but it's also an important part of the case. It's the most compelling circumstantial evidence that prosecutors have. All right, let's talk about what's happening outside. Any reaction from outside court today?
Yeah, so this was another big day, a lot of key testimony and new information. And also those clips keep being played. Clips of Karen Reed with her various interviews that she's given to outlets, and also that documentary that we're also in. So there was an important clip that was played today where she talks about her relationship with Jen McCabe and this case. And it was so powerful, and this is how the day ended. I want to play the clip, and then I want to play her reaction to it outside the courthouse. Let's listen.
Totally more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
Karen, you or Jen McCabe, any reaction to that clip?
I'll have more of a reaction when you hear the whole thing in context. That was 7 seconds because there was a lot of context.
Well, tell us more about it.
What did you mean then? Give him a little spot. If she starts to talk,
You'll see.
doesn't let him go.
Their case is almost over, so you'll see.
Okay, so that was two big things that she just said to myself and the other journalists that were there. Did you hear it? Like, she said that they plan to play more of that clip. They plan to play clips of their own during the defense case in chief. And also she signaled that the state may be wrapping sometime soon, but it's hard to believe because we have so many key witnesses to take the stand, like Trooper Proctor, like we talked about, like the Alberts, like Brian Higgins, and those people took days last year.
They did, each one of them. I'm wondering, though, how much will the new prosecutors streamline the case? You know, you're not obligated as a prosecutor to call every witness who knows something about the case. You just need to present enough witnesses to prove the elements of the crime beyond a reasonable doubt. So we'll see how they handle that. Now, this is interesting. I understand that you got some more information from Karen Reed's father. We were talking about this last night.
Yeah, remember, yesterday you and I were talking about another big moment for the jury. It was yesterday when the jury, the 8 men, the 9 men, the 9 women, saw that video clip, a dash cam video of the welfare check over at Meadows Avenue. Meadows is John O'Keefe's home. And remember, the minors, the niece and the nephew, were there overnight by themselves, so they were doing the welfare check. And during that process, they caught camera of Karen Reed's SUV in the driveway, and it shows the taillight area, and how that's interpreted is up for debate, right? Well, yesterday you were asking me if William Reed saw it up close and personal at Meadows, or if he saw it up close and personal at his own home where the car was ultimately towed away from. So after court ended today out here on the courthouse steps, I asked him about it. Take a listen.
I know it's a blizzard. We get back to the weather, right? It's a blizzard, so nobody wants to go outside. But I'm wondering if he has that knowledge, if he actually saw the tail light when the car was at his house before the state troopers took it over.
Vinnie and I were talking about the statement last night about the broken taillight.
Yes.
Where exactly did you see it? Did you see it at your house or did you see it at Meadows?
I saw it at both places. So when we left the hospital, Karen wanted to see the children. And so my son drove us to Meadows. When I got out of the car, I saw it. And then when I had a cup of coffee and left there, we cleaned off the back, and I saw it as right here. And so I know what I saw.
So there was still red left?
Oh, absolutely. I would not have driven that car, all right, in the blizzard conditions that were present that morning, early afternoon, with anything of serious impairment. I just would not have done it. I mean, you know, I was still very active with Bentley University at that time. I could not have ever risked any type of, you know, citation for, you know, reckless or improper driving during those conditions. So I know what I saw.
Can we expect tomorrow any indication who's going to be next?
I know who's going to be next. I think I know who's going to be next, but
Tell us.
I can't tell you.
Law enforcement, another expert?
I just don't. Well, listen, I'm a straight shooter, but I can't shoot on this one.
Okay, so that bit of evidence is never shared with us. Who's going to be called the next day or who's going to be the next witness. But I have an idea, Vinnie, because when court ended for the day today, I saw Yuri Buchanan leaving the courthouse. So he may be called to the stand first thing tomorrow. Why is he so important? Well, for a lot of reasons. He also sets up Trooper Proctor. He was Trooper Proctor's supervisor at one point in time. He was also part of the internal investigation. He had to give up vacation days because he was part of that text message where Proctor was talking badly about this defendant. But his testimony is so important for the Commonwealth because it ties him to all of the collection of evidence, including the car in the Sally Port, pieces of taillight collected at 34 Meadow or 34 Fairview, and then also Karen Reed's SUV as it's towed away from William Reed's house and over to Canton PD and what happens to it there. So this guy was on the stand for 3 days last year. He's a big, big, big witness.
Oh, super important. And maybe his testimony might replace Trooper Proctor's if he's not called. But by the way, William Reed needs to testify for his daughter. If he saw the tail light and the tail light wasn't as broken as prosecutors are saying, he needs to get up on the stand and tell the jury, because that is a huge issue in this case. It's a huge issue for Karen Reed. And you know, this, I think everyone agrees, prosecutors are doing a much more streamlined, powerful job second time around, so they may need a little more evidence on their side. Matt Johnson, I'll be joining you next week. Get ready. Get some good weather going there, please. Please. Yeah. All right. Matt's in Dedham. We'll be with him next week. We're doing live shows from there, by the way, all next week. All right, let's get right to it. Tonight I'm joined by our think tank live in studio, criminal defense attorney, former state attorney in Miami-Dade, and former assistant DA in Atlanta, Georgia, Daryl Cohen. He's also an actor. Criminal defense attorney and law professor Meg Strickler. And last but not least, the man behind the glasses, criminal defense attorney Josh Schiffer. Okay, let's talk about this. Buchanan, likely tomorrow. Is it possible that he replaces completely Trooper Proctor for prosecutors, that they say, listen, we're not going to call? Because on cross-examination, the defense did a lot to establish in front of this jury that it's Proctor's case. He's the lead guy, it's his case. So is there any chance?
If you don't bring Proctor, what's the message that you delivered to that juror? The most important person we've talked about is not going to appear. Thanks, y'all. Get to beyond a reasonable doubt. It's ridiculous, but I think it may happen.
I think it may
they may not call him.
But Daryl, couldn't you as a prosecutor say, ladies and gentlemen of the jury, Trooper Proctor was the lead investigator, but he didn't have any evidence that I needed. When he got up on the stand, did he provide any evidence that I needed to prove my case to you, ladies and gentlemen? Isn't that what you say? Because there are cases that I've covered in other jurisdictions where the lead investigator doesn't actually do anything, just kind of coordinates everything and isn't necessarily necessary.
Head coach is what I would argue. Head coach is what I would say. Yes, he was the coordinator of all of this, but he didn't provide any evidence that we think would be appropriate for the jury to hear. I would avoid Proctor being there because of what happened at the previous trial.
I agree. Don't put him in there. Don't put him in there at all. You can still build him up as being the lead.
Will the defense call him?
That is the key question. I don't think they will either, though.
It's a call it by the moment. You know, I can't predict it, but it gives a lot of power to the defense as soon as the Commonwealth says, we're not going to call this otherwise incredibly important person. Think of the different ways you can put that in front of a jury. There's so many advantages given to the defense.
Is it dangerous, though, if you call him as your own witness? Because you can't ask leading questions.
It was dangerous before this second trial started. Come on.
I don't think they'll call him. I really don't, because it's too dangerous, and you can't lead him. You're absolutely right. Plus, his bias, I'm going to call it bias, is there for the prosecution, anti-Karen Reed. Why on earth would you call him?
And it begs the question, should Brennan have brought this in the first place knowing part of his journey means carrying a hand grenade?
Yeah. Well, he didn't, and the prosecutor didn't talk about Proctor in his open.
No.
Absolutely avoided Proctor like the plague. So what I would do if I was prosecuting this case, I would not bring Proctor. And if the defense wants to bring him, want to call him to the stand, good luck, boys and girls.
And what will be her expressions when he's testifying? I can only imagine. She'll be like...
And she needs to dial that back.
And she hasn't.
Huge.
So if you put Proctor on the stand, it's going to get really ugly. Really ugly.
I would so much try to bring attention to Karen Reed without saying anything. My presence as a prosecutor, I would ask questions moving toward Karen Reed so that the jury could observe her facial expressions.
Well, there's no way
and
to
her
miss
body
this
language.
This courtroom is about the size of this studio, maybe a little smaller. And it's a courtroom with all these people in it.
It's insane.
And everyone's on top of one another. And that was the defense's choice. They're the ones who got it out of the big courtrooms. I don't know if that helps, who that hurts in all this.
It hurts Karen Reed.
It does.
Because there's no way you can't see her at all times.
No place to hide.
And her expressions.
I think it cuts across both sides kind of equally. As bad as her facial expressions have been, in my opinion, it gives the jury a really close view of everything the Commonwealth is doing, including their scramble, including their bad materials that they have to present. That struggle, you can't miss it.
How about Dad, Daryl? Does the defense have to call Karen Reed's father to talk about? Yeah, I saw the taillight. It wasn't cracked.
If they don't, then they're missing a golden opportunity to negate some of the prosecution's evidence. But having said that, who knows? It's predictably unpredictable.
I agree. We have no idea what's going to happen.
The moment Dad gets up, it's automatic self-serving testimony that could go terrible for Karen. If he gets up, you keep that fast.
Yep.
And keep it focused just on because the pictures are vague, the testimony is vague, and he seems to have a clear recollection of the taillight. We'll see. All right.
I'm a straight shooter.
He's a straight shooter. Straight shooter. It's a shooter. All right. You guys are staying here, not going anywhere for the next hour. When we come back, we're going to dive into some of the evidence, including, oh, wow. This is going to be fascinating. We're going to take a closer look at some of that evidence that was brought in today, plus coming up next hour. Tonight on Vinnie Politan Investigates, we go in depth to uncover the truth about Brian Albert, the owner of 34 Fairview, where John O'Keefe was found. What's his alleged connection to the case, and did he actually do anything that was suspicious? Tonight, we investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates. Tonight, 9/8 Central, only on Court TV.
Is Karen Reed a killer girlfriend?
She's guilty.
Or the scapegoat in an elaborate cover-up?
Karen Reed was brave! We know who did it.
The Karen Reed Murder Retrial. Live coverage weekday mornings, 8/7 Central on Court TV.
What, if any, conversations did you have with Dr. Scorti-Bello about what your unit's theory was about what happened to John O'Keefe?
There was no theory.
Okay. You did not provide any theory to her, correct?
I did not provide a theory.
You learned at the autopsy from your observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes.
You also learned that there was a small cut above his right eye, correct?
Yes.
You didn't see any bruising on his arm, correct?
I don't recall.
You didn't notice any obvious broken bones, did you?
I'm not a medical expert.
Interesting. That's a witness who didn't testify last year. That's Connor Keefe talking about the death of John O'Keefe. That's on cross-examination. But the main focus of his testimony today, and with him testifying, and Buchanan, we believe, perhaps testifying tomorrow, everyone is wondering if Proctor is going to be the odd man out here. But let's talk about Trooper Keefe and what he did today. Take a look at this image. I want to put it up on the screen if we can. He was putting into evidence pieces of taillight that were found, okay, in the snow. So he's got the pieces in court to show to the jury so they get an idea of the size and how sharp the edges may be. But they also got to see the photos of where they were recovered in the snow before he took custody of them and placed them in the evidence bags. Our think tank's still with us. Let's go back to that first one. Go back to that first one. I want to talk to our think tank about that one. Darryl, is this powerful for the jury? I mean, this is the broken taillight.
When you start with red on white, it's always powerful, unless you add blue and it's more powerful. But in this instance, if the jury believes the testimony, this is, in my view, incredibly powerful.
Yeah, I am at the point where the defense has to get this jury to believe that it's reasonable, there's a reasonable explanation, alternative explanation for the taillight there, and it has to be someone is planting the evidence. Someone has, there's no other way. Tell me another way that the taillight ends there. It's either Karen Reed striking John O'Keefe or someone planting evidence. It's this or that, that's it.
And I think what they might do is the famous whistle past the graveyard thing, where this is direct evidence. We cannot get away from that. So what they might do in their closing with respect to this is just be like, cumulatively, there's reasonable doubt. You see what I'm saying? So they kind of be like, what?
But to me, this is one issue.
It is.
There's only 2 ways the taillight it's right next to John O'Keefe's body on the street. There's no other way. So how does the defense going to establish or attempt to establish that the stuff is planted there?
They're not going to say planted. I'm sorry, Darryl. They're not going to say planted. They're just going to keep saying shoddy investigation and point out all the holes.
And I agree with Meg. I think they're going to basically ignore it. They're going to say it was planted, but not say it. They'll intimate it was planted. Look, it didn't have legs. It didn't walk over there, and it was close to where John O'Keefe was found. I think that Meg is absolutely correct. They're going to argue, in my view.
And it appears there was snow on top of some of it.
Exactly.
But they didn't do good reports, though. You don't know how deep where it was found, how deep it was. There's not a lot of good investigation
But it's found
here.
there. Like, it's found there.
But wrapping it into the sufficiency where they don't have to go specifically provide an answer of how it got there. The question is, why wasn't this discovered at the incident time? Why did this evidence handling, why was that evidence handling performed so poorly in comparison to what we would expect professional law enforcement to do?
Disagree.
No, well, it's not that the Commonwealth doesn't have a problem with this piece of evidence that they will admit could have been handled better.
Could have been handled different.
Everything could have been handled better.
It's in the snow. When it's snowing, something that weighs anything at all drops through the snow unless it is so cold.
From the time police arrived, there was about 3.5 inches.
Right.
By the end of the day, later in the afternoon, there's more than 2 feet of snow.
Right, they had the meteorologist testify yesterday about how horrible
Is that
the storm
not the
was.
simple explanation for why it may have taken a little longer to find the taillight pieces? We're in the middle of a nor'eastern blizzard?
It absolutely makes sense, and it's a convenient belief because it would make a lot of sense. But if you're really questioning the taillight, which really, by talking about it, every time they talk about it, more questions get raised. And people are eventually going to ask, hold on, even though they didn't say, how would a body break this taillight?
Yep.
I'm an independent juror. Man, maybe I've cracked a taillight. Maybe I know that it's not something that just shatters easily.
Right. To me, that's a separate issue.
Absolutely.
We know it shattered. It shattered one way or the other. Somebody broke the taillight, right? We know the taillight's broken. The question is, how did the pieces get there? Now, there were also clear pieces that were found there as well.
Right.
That was shown to the jury. And to me, that's significant, too, so the jury understands that, hey, the taillight is not just all red. There's different parts to this taillight that I believe if they do like they did in the first trial, they'll put those pieces together for the most part, although they have not recovered every piece of that tail light.
Which is interesting as well.
Right.
And the real problem is that every time the Commonwealth can't lock this down 100%,
there's reasonable doubt.
Boom.
Yep.
I so disagree.
The tapestry is not full.
The prosecution is now using the KISS method. Keep it short, stupid. Keep it simple, stupid.
I don't know
have
if
to
I agree with that.
complicate
What's
it.
up with the expert today? No, I don't know if I agree with that.
No, there's no reason for them to make it any more intricate than it is.
They should.
Let me show you another piece of
trying not to
evidence.
make it
There's another
intricate.
piece of evidence that maybe, we know the theory on the taillight. They're going to say Trooper Proctor had 15 minutes from the time the car was brought back to the Sally Port to go behind it, break it, grab it, bring it over, and then either with the officers that were there, suddenly plant it, or dupe the officers that were there and plant it and make them hey, look over there, guys. Then you hide it, and then they find it.
An incredulous idea, to be blunt.
So the bottom line is all the officers there probably have to be in on it, right? So now there's another piece of evidence, significant. John O'Keefe's shoe. When he was found, he was wearing only one shoe, so they knew they were looking for a shoe, and they found a shoe. If you look on the bottom, it's up against the curb in the street. It was buried under snow. What about the shoe? If someone's planting the shoe, who's planting the shoe? When are they planting the shoe?
It's a Nike, so they just did it.
I get it. That's good. But who?
Well
to me, this is more difficult. I don't know what the theory is. Someone else has to plant the shoe. When do they do it?
But
who does it?
We don't need an entire alternate theory. We just need reasonable doubt.
Yeah.
So remember that one issue when you're
Right,
talking
but
about
I don't
the
even
shoe.
know what the theory is.
The timing is a very strong issue for the Commonwealth to show that it had been out there for a long time.
Yeah.
And that's what I think Vinny's talking about is...
But who had opportunity to plant the shoe?
I think that's an almost impossible, if not impossible, question to answer, which is why it's such a good piece of Commonwealth evidence.
The shoe might be stronger than the tail light.
Yeah, he
How
didn't
about
go
that?
inside the house without the shoe. If you feel that the shoe was outside for a long period of time, that eats up the whole...
And we-
I could just
And one thing we know...
If you're very drunk, you might have gone in there not knowing
Right.
it. You gotta,
We're not
you gotta
talking about my
argue.
college time when I didn't have my shoes on. That was one time.
And
You could lose the shoe in the snow and walk around?
Yes.
Really?
Personal
No.
experience,
Yes,
That spelled
right.
no.
I can say you could.
we don't have that long because we got to talk about Haslong. When we come back, another expert for the prosecution talking about Jennifer McCabe's search, her Google search. When did she do it? 2:27 or after 6 a.m.?
And you'll learn that according to the Commonwealth's own evidence from a forensic software program called Physical Analyzer made by Cellebrite, it's considered the gold standard for forensic tools. You'll learn that a Google search was discovered on Jennifer McCabe's phone. A Google search that Michael Proctor and his investigators never revealed to us. But we found anyway. A Google search that was time-stamped according to their own data at 2:27 a.m. 5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, Haslong to die in cold. How long to die in cold? Now, she misspelled the first word. Haas is supposed to be how, but the meaning's the same. How long does it take to die in the cold? Timestamped 2:27.
So this evidence really was the birth of the defense conspiracy theory and the Free Karen Read movement. This 2:27 a.m. search by Jennifer McCabe. Now, what you have to understand about it, and Alan Jackson explained it, but I don't know if the jury's going to fully understand it, why they were so passionate about it. Because they got the first reports in discovery from the prosecution, and there was no mention of it. They ran their own report with their own expert, and their own expert uncovered it. So the defense felt like they were hiding this evidence from us. But what turned out to be was they ran different versions of the program, and the prosecutor ran the old version, which didn't uncover this. So now they've got to clean this up, the prosecution, right? Absolutely have to clean it up in front of this jury. Jessica Hyde, another expert they hired, here testified about when the search was done.
For clarity, there's more than one search that happens actually at 2:27. There is some activity that's looking at, and I don't want to mispronounce the name of the town, I'll try Hockomock Sports, looking at activities for the sporting events at that school system, I assume, or county location. There is a timestamp for the search, Haas Long to Die in Cold. However, that timestamp isn't about active searches. It's about the time that a tab was either opened or moved to the background. So Haas Long to Die in Cold is the most current search in the tab that you opened at that was opened at 2:27. So if you're using your phone and you go to your browser, you have some choices. You can just open an existing tab, or you can open a new tab. A new tab was opened at 2:27 a.m., and that search was done there. Another tab, actually at 2:27, was moved to the background, and its last search at the time it was moved to the background was for, I believe it's Raining Men, the YouTube video. So those two searches both exist as what's called browser state searches, but that browser state isn't about the time that it was searched. It's about the time that the browser tab that you opened either went to the background, or if it's never been moved to the background, the current search.
When you use the Celebrite tool to analyze the 2:27 search, did the search How Long to Die in the Cold have a timestamp on it?
There are actually multiple artifacts for How Long to Die in Cold. Remember earlier we defined an artifact and we spoke about it was one of the types of traces. So there are multiple traces for that How Long to Die in Cold. Only one of them is associated with the 2:27 timestamp, but there are other instances of evidence of that was parsed by Celebrite. At 6:24, we have two timestamps in the same two locations for How Long to Die in Cold.
Can you tell us, to a reasonable degree of scientific certainty, your opinion about whether that search, How Long to Die in the Cold, occurred at 2:27:40 a.m. on January 29th, 2022?
There's no objection, Your Honor.
Okay, the objections are overruled.
What I can state to a scientific degree of certainty is that that search occurred at 6:24 a.m. and was the last search in the tab that had been opened at 2:27.
That was the direct testimony. How did she do?
You wake me up?
Gomer Pyle from that old television series, surprise, surprise, surprise. I thought she wasn't great, but I also thought she knew what she was doing, and she will come across quite well to the jury, who I think will relate to her.
I thought he was going to say Shazam.
I love that. I actually liked her, but I understand what she's saying because I do this in my own job, so
Right.
I understand what she was saying. I don't know if the jurors
Did it go
got
over
it.
their heads?
It has to, because I mean I had to learn it myself to do an expert like this as well. So it took a lot of time for me to understand it. The first time through, the juror's going to be like, Okay, when's lunch?
But it's so important.
It's so important, but it's kind of a nuanced issue, and this is really complex to explain to anybody.
Correct.
So that inability to explain a complex thing cleanly to a jury is a problem the Commonwealth has.
Yeah.
They didn't score 100%. They did 80, 90. It was really good.
All right.
But there was no, oh, absolutely.
Yeah, he
You
wasn't
want to see the
perfect.
cross? You want to see the cross?
Yeah,
And
of
with
course.
a bang. That's what she did.
There you go. Let's take a look at the cross now.
We cannot tell by this particular artifact what time that search occurred. Did
Absolutely.
I read that correctly?
It's specifically pertaining to that particular artifact that in browser state DB that does not tell us what time a search occurred. That is correct.
Right. So you stated, and it was your statement then, we cannot tell by this particular artifact what time that search occurred, correct?
That particular artifact.
Okay, so now let's keep going.
Mm-hmm.
If you go to page 129 of this transcript,
I'm there.
at the top,
Sure.
line 1, 227 isn't necessarily one time when the tab was closed. That's in my report. I say it's undetermined. Remember we were just reading your undetermined
Absolutely.
in your May 23 report?
Correct.
Because there's a lot of things that can cause that timestamp to be there, including tab being moved, tab being minimized. The next sentence. I don't know exactly what caused the tab to get that particular entry, but it's not, that timestamp is not indicative of the time of the search or any URL that's visited. But the first part of it is, I don't know exactly what caused the tab to get that particular entry. Did I read that correctly?
You read 100% correctly.
Celebrate remove the timestamp from their tools.
Celebrate did remove that timestamp from the tool. That is correct.
Okay. And that timestamp was the subject of extensive reports and testimony that you participated in the first proceeding, correct?
That is correct.
And even though that timestamp, 2:27:40 a.m., that showed up in Celebrate Tools, Magnet Forensic Axiom showed up, that was removed by Celebrate, correct?
Celebrate no longer reports it. The evidence is still in the data. I want to be clear, just that it doesn't change the data. They just removed it from their automated parsing and reporting.
Right, so they
Correct.
removed it from their automated parsing and reporting, correct?
Yes, they did. That is correct.
However, your former company, Magnet Forensic Axiom, still shows it, correct?
Magnet Axiom Forensics currently shows it as a carved artifact and still shows that and gives a description in our artifact reference guide as to what they believe causes that artifact.
I'm going to ask the question.
Yes, it does.
Magnet Axiom Forensics, where you used to be the director of forensics,
That is correct.
still shows that timestamp,
Yes.
right?
Okay, here's my question. This cross-examination is pointing out that Celebrate has changed their program. That 227 now would never show up, but the experts company that she works for that does the same kind of work still shows it. Is the defense alleging that Celebrate is now part of the conspiracy?
No, not at all. Not even remotely.
What are they? What's the point here? What are they? Because they're going after Celebrate.
Yeah,
They
they're
sure are.
absolutely going after Celebrate. So what is the jury to take from that? That Celebrate wants Karen Reed convicted?
Not even remotely.
Anybody but Karen. And by the way, you said it before, Shazam, she got him.
It depends on how you're going to attack this, because you could attack...
They're attacking Celebrate. There's no doubt that they're attacking Celebrate.
You can attack Celebrate and say they're just a tool for prosecutors, so they remove this functionality in order to help prosecutors with these sticky issues. If they can
That makes them part of the conspircy in this case.
And if the defense can communicate that. But did the defense communicate that?
But I agree with Josh. What Josh just said that I think is the perfect issue is, after all that's said and done, and the jury went home tonight, what did they walk away with?
Yeah.
They walked away with her final statement as she was being questioned.
She did say something about the Faraday bag at the very end. No, but at the very end,
It's
she
Vinnie
was
Barbarino. It's Vinnie Barbarino, right? I'm so confused.
Boom. Confused is a defense win. And after listening to all that expert testimony, and she did a great job.
It's not. I don't think it's a defense win. And I'll tell you why.
No, I don't think it is either.
This is not a winning issue for prosecutors.
That's true.
This is a winning issue for the defense. If they win this issue, the trial is over.
They didn't win it.
So a push does not help the defense
They
here.
did not win it. They just put in some holes, and that's what a cross generally gets.
Yeah, but they don't need holes. They need to win this. This is the get out of jail free card for Karen Reed.
When she
That's not what happened on this
their
witness.
final bit of testimony, bam, over and done. I think that they never should have cross-examined her as a defense lawyer.
But she pointed out the fact that they didn't do that Faraday bag at the end, and that was a good ending, and that was something that you walked away with. At the very end of the cross, there was a bam. And I did walk away from and say, all right, they did score points.
And what Meg's talking about, what did they actually go home with?
Yes.
I listened to a whole day of this argumentative. They're avoiding each other. They are clearly prepared. They are into it. I walk home and go, wow, whole bunch of, I don't know what's going on. I don't know exactly what happened.
So what's your take on it?
My take on it is her testimony was confusing until the end, and she slammed it, jammed it, and that's what I go home with. That's what, as a juror,
wins that
absolutely.
Okay, all right. Great job tonight, folks. Thanks. Daryl Cohen, Meg Strickler, Josh Schiffer. We'll see you again really, really soon. By the way, folks, when we come back, I will reveal something else you need to know tonight, plus coming up next hour. Tonight on Vinnie Politan Investigates, we go in depth to uncover the truth about Brian Higgins, the man who exchanged flirty text messages with Karen Reed. What's his alleged connection to the case, and did he actually do anything that was suspicious? Tonight, we investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on Court TV.
You watched while your patient was lying there, being tortured.
What else was I supposed to do?
So much for your career in caretaking.
Interview with a Killer, season finale, Sunday at 8 on Court TV.
Time to reveal something else you need to know tonight. Let's take a look at the big board. Acquitted. 3 former Memphis police officers were acquitted Wednesday of state charges, including second-degree murder in the fatal beating of Tyre Nichols in Memphis. Let's take a look at the moment inside the courtroom.
The verdicts read as follows. Count 1, second-degree murder. We, the jury, find the defendant, Tadarius Bean, not guilty. Count 1. We, the jury, find the defendant, Demetrius Haley, not guilty. Count 1. We, the jury, find the defendant, Justice Smith, not guilty.
A lot of people shocked by that verdict. Now, they have been convicted of some lesser charges in federal court and will be sentenced there. But make no mistake, this is an enormous victory for these former police officers. I need you to take a look at your television screens, folks, because we have a missing child tonight who needs your help. This is Gabrielle Perron. Gabrielle has been missing since May 5th out of Fort Lauderdale, Florida. Just 16 years old. She's just 16. If you see Gabrielle, please pick up the phone, make a call, make a difference. 911, 1-800-THE-LOST, or you can call the Fort Lauderdale Police Department down in Florida. That phone number's on your screen. Let's see if we can get Gabrielle to a safe place tonight. Don't go anywhere. We have another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.